Good morning, friends. Adab, Sasryakal and Namaskar. This is my 211th video, and this is a very important video because it directly concerns me and my research. It is about bungalow number 102 Ambala Cantt, which was owned by my father and mother, late Shri Shyam Sundar Das and Shrimati Savita Das. The bungalow was given a resumption notice by letter number 69 of 21st March 1975, equivalently having a date of 7th April 1975. This bungalow, survey number 356, holding an area of 1.60 with a built up value of 64,126. Like any other bungalow owner during those periods of 1975, 71, 2, which I just in my earlier videos mentioned about Ambala, my father, being a businessman and a friend of one of the most learned advocate, Bhaktavar Singh Libherhan, they filed a suit for declaration. The suit's pleadings, since the entire case is with me, which I bought from High Court in 2003, because when I inherited this property after the death of my father in 1999, I could not even spell cantonment. So 2003, when the RSA notice came to me after 28 years of its filing, it was a shock for me, and this is how these files came to me. And then I gradually typed every order of the file, every bit of the file was typed. So now what does my father and Sardar Bhaktavar Singh Libherhan plead in his case? That the notice is illegal, void, unconstitutional and against the principle of natural justice, and therefore ineffective, and therefore not binding upon the plaintiffs, and the defendant has acquired no right, title or interest therein. So this is the suit for declarations heading. Now we'll go for the pleadings. I'll definitely read you all these pleadings. I will read you the session court's order and the high court order then. The resumption of property cited is very vague and is definite, and no grounds or reasons have been mentioned in the notice of resumption, and the compensation is highly inadequate. The said notice served on plaintiff is illegal, unconstitutional, without jurisdiction, ultra vires of the powers of the Deputy Director Military Lands and cantonments for the reason and grounds hereinafter set out. That no property belonging to the citizen of India can be acquired by the President of India or any other except under the laws made for the purpose. All contracts, agreements, rules and regulations previously enforced shall cease to have their effect of enforcement after the Constitution of India, that is 26/1/1950. And no part of the property can be acquired, resumed or taken away from a citizen of India except in accordance with law and again for public purpose on payment of proper compensation. The power to resume is a direct in conflict with the provisions of the Land Acquisition Act 1894 and the Cantonment Act 1924 and the House Accommodation Act 1923. That no public purpose for resumption has been mentioned or stated in the order of resumption. That the order or discriminating in as much as the bungalows of private holders in Ambala Cantonment have not been acquired and in the vicinity of 102 Mall Road. The rules and regulations have ceased to have a force of law after the Constitution Article 13. The notice is otherwise illegal because the lease granted by the government cannot be resumed unless compensation of the said leasehold rights is adequately paid. That no notice has been given before resumption to the plaintiff. Consequently, the resumption notice contravenes the principle of natural justice. A department or the defendant has no right to forcibly dispossess the bungalow owner or the person in possession of the property. The order of resumption vitiates the illegal order of quasi-judicial nature and was objectively decided by the government. The present value of the bungalow is more than about 4 lakh rupees and is much higher from the inferior building which has been paid. Similar buildings situated have not been in Article 14. Discrimination stands too. So it was a huge plaint of about 16-17 pages. A written reply by the plaintiff is by the defendant is very important. The plaintiff are now unauthorized occupant after the resumption notice under Public Premises Act 1971 are already going on regarding the land in dispute in the court estate. So when the resumption notice was issued, simultaneously after 30 days, a PP Act notice was also issued under Section 4.1. But as usual, the bungalow owner, late S.S.Dass, went in for a suit for declaration and became a plaintiff. So under Section 15, the department says the jurisdiction of coming to court is debarred. Well, that's right. And the other case in Sagar, they said Section 40. Here they are saying Section 15. So that the plaintiffs were merely a license of the land, which I just mentioned. President of India is not bound to give reasons to resume the property. See the arrogance of the office, towards this 102, the Mal. The present case cannot be termed as acquisition in any provisions of the Land Acquisition Act or the Cantonment Act or the House Accommodation Act, as they do not apply on this property. Now just imagine they are pleading that neither of these three acts, LLA, Cantonment Act and House Accommodation, does not apply because it's just the Governor General order which applies. What is the department doing and what were we pleading? Just understand, the government land measuring so and so was given to the plaintiff free of rent and on clear terms of the GGO 179 of 18. So that means the GGO alone rules us, the Cantonment Act doesn't rule us. Then how does the Cantonment Act becomes applicable on us? Very vicious doings, And unfortunately, the judiciary and the lawyers did not know what the whole briefing is. The matter is entirely contractual nature, and the Article 14, 16 and 19 of the Constitution do not get involved in it. He says there is a contract under the 1872 Contract Act. It should be no lease was granted to the plaintiff, and as such no leasehold rights are held by the plaintiff. The plaintiff is merely occupancy holder. Now this is again a very important question which could not be vetted then. Does not violate Article 14. The government have already been resuming many bungalows in the cantonment Ambala. It's very important. So the advocate files an application. The dispute raised by defendant before the state officer is again unsustainable for the reason that the MU and the state officer, being on the same person, hits the principles of man cannot be a judge of his own cause, and therefore the principle of resumption is ultra vires as well as against the natural justice. The plaintiffs are not licensee. Contrary, they are the owners of the property. The property cannot be resumed unless a specific purpose is stated and told. The court passed an interim order in this application for injunction. This was in 1975, 7th November. Well, everybody did that. Another that the application on 39(1) Rule 2 is also applied for a status quo and exemption. The department comes and the status quo is granted. Now, what were the issues made? That's very important. Whether the notice, impugned notice detailed in para 2 of the plaintiff is illegal, unconstitutional. These are the same notices done in bungalow number 18, 19, 68, 68A and 71 as alleged. Whether civil courts have jurisdiction, fine. But here there is an added issue. Whether the plaintiffs are owner of bungalow number 102, the Mall Ambala Cantt, as alleged, This issue will also cover allegations of the defendant that the plaintiffs are only licensee. OPP. Now the question is, an issue of ownership has been made. So this extra issue has been made now. So should I call this was a curse, because those bungalows were never appealed. Now this bungalow ultimately faced his fate in the High Court. Now what does the court say? Where there is no dispute about the services of such notices, there is nothing to show that it satisfies the requirement of law, in that aggrieved party had been given the opportunity of being heard. The market value had been determined in a legal manner. There was no pick and choose in the matter of resumption. And lastly, that a definite public purpose was sought to be served for the proposed act. This is, however, not a word of evidence on the file to show that the plaintiffs were given an opportunity of being heard or mere otherwise. In this behalf, a DW3 Devki Nandan GE has been brought in, and he minced in no words in admitting that he had not given any notice to the owner before taking the valuation of the built up area. This lends strength to the allegation that the job of the valuation was undertaken and finalized unilaterally and arbitrarily. Again, the valuation of the property was undertaken by GE North. Now, in one case, we are considering a contractor method. Here, we are taking the PWD system and the G is coming. Statement Exhibit D2 and D3. However, he has not been brought to the witness stand, reasons which have no explanation forthcoming. The G North never came to the court. In case he had been examined, it would have been proved whether an opportunity to the plaintiff to examine the valuation was given or not. This has serious prejudice. The case of plaintiffs have rightly challenged the correctness of the valuation. It was held in Bhagwati Devi, President of India, 1974 RLC, that you cannot be arbitrary. This is a clear discriminatory and contrary to the policies framed under the resumption policy 73150 RQ3 29/6/1969, exhibited P2. Now imagine there is this resumption policy on records brought in by my father as an exhibit P2. P means plaintiff, D means defendant. That states held on old grants and tenure as and when required for specific army projects, works, cases will be proceeded by the army headquarters. As far as possible, these cases will be taken up zone wise based on a construction permission by the Ministry of Defence Finance. In such cases, bungalows should be resumed in a compact block and not in an isolated side pocket. The proposal of resumption should be invariable, be linked and correlated to the overall plan of the cantonment. Now, bungalow number 68, 68A are in vicinities. Bungalow number 18 and 19 are front and back, and the area which comes to the department was running down to about 23 acres. Here they are resuming a bungalow 1.61, which is not even 1.6 acres, which is in an isolated format. And then the president, he says, he has got no reasons to define the specific purpose. This is what the DO is saying in his written. Sought to reserve, exhibit P1, completely silent on this respect. So what are we talking? So now the court says, in my opinion, that the impugned notice is illegal, unconstitutional, without jurisdiction. The issues are decided in favor of the plaintiff and against the defendant. Now these issues were decided in favor of the plaintiff. Now issue number 3, which was the ownership issue. Now, and this is where we all must listen. Now the recital of the conveyance deed clearly shows that the property is an old grant, because my father and the predecessor who was selling had taken proper permission from the ministry, and the sale document was drafted by the DO or the ministry. So in the ministry gets you imbibed in the sale deed that this land belongs to Governor General Order so and so under old grant terms. This is very funny. You know, in a document of sale where two people are selling and buying, a third party is dictating terms and getting modifications done in the sale deed under TP Act. So just imagine now what the court says. Further, they had applied for sanction for transfer of property in favor of the Wendy's plaintiff to the appropriate military authority. In view of the above, plaintiff cannot be heard to say that it is a freehold old grant. Now, what is the department pleading in its written application? That it is rent-free old grant. Here he says freehold old grant. So, he is mixing two things. Whether I am a freehold or whether I am an old grant. Whether I am a rent-free, that is revenue-free. Contrary to the GGO, because GGO has been imbibed in it. While holding the view above, I am guided to the consideration that the rights of the plaintiff is subjected to the same rights and obligations to which it was subjected to the properties was in hands of the alieners, naming Mr. Brijbhushan and Gopinath, from whom the plaintiff acquired title. They are therefore bound by the terms and the conditions before the transferee. In view of the above, I am of the opinion that the property is an old grant and can be resumed under GGO 179. The plaintiff can still claim it to be a case of freehold grant. This is the line what the observation came from the Honorable Court. The plaintiff have stepped into the shoes of their predecessors in interest and are bound by the same terms and conditions under which the property is held by their predecessors. Friends, I will stress here now. I'll cut the judgment part and I'll talk. This is where now after my research, now after losing from High Court and giving next 10-15 years to my research, I realized we were a freehold grant because we were a revenue free grant. And it was very easy because they had admitted that I am a revenue free grant. I am a rent free grant. And where is rent described needs to be interpreted. So these are the things. And then he says, I've stepped into the shoes of the predecessors. Okay, fine. My father didn't dig the records of the land records. He only had his sale deed from 1957 and then 62 when he bought. So what prior to that? Today I have my sale deeds of 102 bungalow, which was originally 254. I have it from 1872, which clearly reads land along with building was sold. What do you do? I've lost. Imagine. So the judge says I can yet claim it. The relief in view of the findings of the above issues, the suit of the plaintiff succeeds and the degree for declaration to the notice so and so issued by Deputy Director Military Lands, New Delhi, relating to resumption is illegal, void, unconscionable against the principle of natural justice and not binding on the plaintiffs, passed in favor in peculiar circumstances, however. So fellow friends, this case was fought with no evidence, no documents, no law, no rule. You just for the heck of it spoke. Bungalow falls within House Accommodation Act. You don't even know where it is written when if the House Accommodation Act is applicable on you. The Cantonment Code, CLA rules and the Cantonment Act debars you from being resumed as per those written policies in the Acts of 1864 to 1924. I couldn't have been a CLA rule, I couldn't have been a Cantonment Court property, because in House Accommodation Act it was written if the bungalow is in possession, it can only be purchased, not resumed at the option of the owner. But these facts were not there. Today I have the speech of the Parliament of 1882 when the Cantonment House Accommodation Act bill was being made and debated in Shimla Parliament. So the judge pronounced his order and this is how things happened. I would share it with you people that when this, first appeal was filed by the DO Ambala or the MEO then, my learned advocate moved an application under section 24 and 38 of the CPC of Punjab Courts Act. It was basically to transfer the case from one judge to another judge, because the particular judge where the case was marked after that appeal, he had already pronounced a similar order in a similar case. So my advocate had an apprehension that since the mindset would be same, so why not transfer? So these things can also happen. We can ask the court for these applications, and I don't want this case to be argued at this judge. Yes, this has to be allowed by the honorable court itself, but if not satisfied, we can always go in for an appeal on this, because this section has an appeal. Sometimes, these advocates these days say, no, the judge might take it adversely, and then there are families, so this travels into them. No, yaar. I'm being honest, and I have got nothing against the honorable court and the judge individually, but the law and the CPC allows me to move this application. So why is my advocate in today's 2020 and 24 so reluctant? Well, forget it. This was allowed. So Union of India, when they filed their appeal with an application for condonation, again they were late here. Like they were late in the Sagar Cantonment case, they were late here either. So the issues decided by the learned trial court 1, 2, 3 were wrongly relied upon. The plaintiffs' authority cited a lot of judgments, especially the judgment of writ 15145 of 1971, decided on Honorable Delhi High Court on 1980. So the application under condonation limitation 5 has been filed, and various issues have been written into it, that why they could not file it. It went to the legal cell, and then remembrance, and then the legal opinion, so on. So the civil appeal number 33 of 1981 was finally decided in 83. Whether there are sufficient grounds for condonation of delay, this application of condonation of delay has no merits in the application, and consequently the appeal are hereby dismissed. The parties are left with the cause. So the suit is dismissed. Now there is a degree sheet also made for dismissal on limitation. Generally, if you find that on limitation, if it is dismissed, the degree sheet is not to be made, but here it is made, because there was argument on the condonation. Now this case filed in the High Court in 1983 as RSA number 1999 came up in 2003, 27 years after my father's death. Friends, we have to understand everything. Now in 83, what is the grounds of appeal, what the department then files? The judgment degree below are illegal, erroneous, against facts of law, and thus liable to be set aside. The learned district judge has dismissed the appeal, the appellant Union of India, only on the question of limitation. Now this is very important. The learned district judge has brushed aside the oral and well documentary evidence on flimsy grounds. The documents, well or oral documents produced, that the learned trial court has erred in issues 1, 2, 3 against the appellants. Now here the appellant is Union of India. The respondent is perfect ally legally, constitutionally, and not without jurisdiction, and ultra vires the power of the Deputy Director Military Lands, now redesignated as Deputy Director General Lands. So there was an issue raised that whether Deputy Director General Lands was delegated the powers to sign a resumption notice, but it was not vetted, because the order of 1957 authentication rules and orders was not there or was not known. So the stress on delegation of powers was not picked up. It was only said that he doesn't have power. Maybe my father, being a little vice president for 17 years, was aware of all this, so he raised this. Mr. L.S. Mendes was here at that time. So he was dead against my father, because in 1977 only my father got Ambala excised. The department was not at all willing in 77 to excise the civil area. In 1957 they excised Agra, but they took the land records to themselves. But here in 77 even the land record was transferred. So I can imagine, if I go back to 77, these officers sitting in the IDS seats were dead against my father. They were dead against. So unauthorizedly the PPA Act has been initiated and the notice has been stayed and what all, these are the. So on these grounds of appeal, finally the RSA is filed. On arguments, what is the court writing? RSA. Is illegal, null, void and unconstitutional. These are all paras which it reproduces in its judgment, and I'll further read how things proceed. Notice was accompanied by 64,000, House Accommodation Act, discriminatory. These are the pleadings which my father had taken, which were re-reflected in the High Court judgment. Now here I had decided to take the first fight to the limitation. By this time I was not an advocate, or I had not even pursued law, but I could understand with my research what is law. So with my mentor, Mr. M.L. Gupta, I discussed that this appeal speaks that first appeal was dismissed on limitation. The grounds of appeal also speaks. So section 100 says that if any first appeal is dismissed by limitation, you cannot file an RSA, you have to file a revision under section 100. So I said, can't we take this point further and argue on it that the RSA itself is wrong? So he liked he was a man of 70-80 years of acumen in judiciary. He had stayed as a session judge. He says, you work hard on it, and I worked hard. So later in this judgment, you will see how the court was brushed to the section 100 of CPC. But I remember when the arguments were being done and the judgments were playing, the court kept insisting to show me a judgment in which a judgment coded by the Honorable Court, which is discussing the limitation and the High Court Punjab's case. Show me any judgment, he said, which is discussing this judgment. It's not necessary the judiciary will discuss every 1,000 or lakhs of judgments in every case of it. Mr. M.L. Gupta even gave a judgment of 2010 section 100 Supreme Court. So we'll talk that later. So on the outset, the objections had been taken. Learned counsel for the respondent defendant had about maintainability of the rent, on the grounds that the first appeal had not been decided on merits and rather has been dismissed on limitation, and that is what the grounds of appeal. So revision under section 115 of the CPC code should have been filed and not a regular second appeal. So it has also been held that it is the duty of the court to formulate substantial questions of law when hearing and grounds of appeal section 104 and 100 subpara 5 of the code. The question of law can be permitted to be raised at any stage of the proceedings. Hence, in the view legal propositions, learned counsel for the appellant defendant was asked to file substantial questions of law stated to the arising in the appeal. Hence, there is no force in the arguments of the learned counsel for the respondent plaintiff that the regular second appeal is not maintainable. So what do you do? Friends, when I was fighting this 2011 High Court, I remember 90 hours of argument. Everything is with me in records. It's unbelievable. It's unbelievable. But to that knowledge which I had in 2000, the expression sufficient cause employed section 5 of the Indian Limitation Act 1963 and similar other statutes, it is elastic enough to enable the court to apply the law in a meaningful manner which subserves the ends of justice. So now, under the sufficient cause of this which is written, the limitation is like a prerogative of the Honorable Court whether to do it or whether not to do it. And to serve the end justice, it finds it needs to do it, so it does it. But remember, if I had the Saga judgment, if I had the Mannalal Agarwal judgment, what difference could have been? So now the substantial question of law was drafted in this RSA after 27 years. What were those questions? Whether the notice of resumption 7/4/1975 is illegal as a condition precedent to give opportunity of being heard and determine the compensation. 1. Whether having coming to the finding and held proprietary in the suits on old grant basis, the notice issued under GGO Regulation 6, Clause 6 could be set aside arbitrarily. Now look at the courts making these. Whether the impugned degree and judgment rendered by learned court below are against law, whether the appeal could have been dismissed, barred by time and so on. So all the 4 issues, substantial questions of laws, are made by the Honorable Court without the counsel of government pleading. I yet remember that counsel. She came out and she congratulated me and Sanjay Majithia on section 100. She says, I have yet to hear an argument on CPC section 100 and 150 of limitation. But the court didn't listen to us. The counsel is congratulating us. Now, these substantial question of law, never come across such substantial of question laws in any of the court cases. So, we need to be. So, what is the court trying to say here? You know, here I remember when the substantial question of laws and we were moving out, I remember Mr. ML Gupta telling me, Puttar ji, mainu lagda hai the courts is not going to be favorable to us. So the mindset needs to be studied. Hun dekh li tu, mehnat te kar raha hai tu. I would prefer you file something. वो कह के हुन वो चले गए. Now I was left. I was discussing with Sanjay Majithia and Shailendra, my advocate. Let us file cross objections now, because I had been insisting it in the beginning of the RSA only when it came up. Let's file cross objections. But because my case was dismissed in default, 3 years it went in default. It was dismissed. Again it was raked up. Again it got dismissed. Then again the DO Ambala and the local advocate Prem Sagar, they both connived and they raked up the issue with the local council in the High Court, and this case again was raked up after 3.5-4 years after dismissal, like the earlier suits of Sagar and all were dismissed, and this restoration of condonation was done. My bad lucks. Everything was working against me during that period. So the ML Gupta said, do something. And I kept insisting with Sanjay Majithia, we have to do something. So arguments were, Sanjay was more keen to let's finish it off. I yet remembered, you know, Dad's like a buddy, I wouldn't call him a friend, but a very senior counsel now, Mr. ML Serene. He told Sanjay, don't argue your case in front of my lord. Please take an opportunity, take a date or get your case moved out from here. But Sanjay kept insisting, no, let's finish it for once. Because, you know, we had done a lot of research, we'd done a lot of hard work, regular meetings. And I can understand even the advocate wants to, you know, finish off. Because he's got his fees, he's got his work to do further on. That the present regular second appeal is lying admitted since 1983. And hence, she does not press the remanding this case to learned first appellate court for a fresh decision, afresh on merits and points involved in the case. Now, the Counsel Union of India is not asking for a remand back. Why? Because she knows if this case goes back, I will lead evidence and I will not let this bungalow go. So she is, and the court is listening to her. When we pick up and say, no, we want it to be remanded back, we want to move additional cross objections, now see what the court will say. Rather, it has been contended that appellant defendant does not press for reversing the findings of the facts recorded by learned trial court, and however it is argued that the present appeal be decided only on substantial question of law. As framed, as learned trial court has committed illegality in digging. So this entire case has got nothing to do with the lower court, nothing to do with the session. It is only on now substantial question of law on grounds on appeal. Just see. After holding that respondent plaintiffs, the property in dispute. This is very important, friends. Understand, counsel on either sides. Why didn't my counsel stood up and just argue? No, we wanted remand back because we want to file cross objections and we want to lead evidence on the finding what the lower court had given, that we can still claim it to be a freehold grant. Even I was not so sharp and well read to the legal words then. I am not saying my advocate made a mistake, or these were destined, and then you know how much you know the law. Everywhere you don't expect things to move the way you want them to move. So, and already it had been 20 years and the judge was, you know, quite paranoid with this thought and perplexed that, okay, after 27 years, he even said in the open court that, Mr. Das, I have known your father when I was posted in Ambala as an additional session judge. And he was a very educated man. So somewhere those things were playing. Friends, we have to educate ourselves. If we do not know the basic laws, we do not realize what will happen 12 years down the line. Now I know why additional evidence was disallowed. So now I'll tell you, I moved an application. I did ask my counsel. It may be mentioned here, the court is saying that after hearing of this appeal, so the appeal was heard on merits on the substantial question of law as framed above, and after the same was reserved for order by this court. However, before the court could pronounce the order, an application under Order 41, Rule 27 was moved. Because I remember Sanjay was not willing to do it. So forcibly I took Shailendra into my preview. ML Gupta said, so we moved this application. Now this application was not drafted by ML Gupta. It was Shailendra's wisdom which did it. There were so many lacunas when I read back to that application today, and it was disallowed. It has been a word that while all the issues were decided in favor of the respondent plaintiffs by the learned trial court, and the suit was decreed. And however, while deciding issue number 3, it was observed that respondent plaintiff have stepped into the shoes of the predecessors in interest and are bound by the same terms and conditions under which the property was held by the predecessors in trust, and hence respondent plaintiff intend to challenge the finding of the learned trial court issue number 3, which they should have done then. We didn't do it because we won the case. This is what the normal phenomena is. This is what I remember Mr. Ankleshia did when he did when we were in Pune and he had already won his Bombay High Court case. He lost in Supreme Court then. This is what Robert did from Shillong. He had won from Shillong High Court. I kept pestering him. No, Mr. Das, Supreme Court, he lost. Sometimes, you know, we don't realize there are some areas which are grey areas in our lower court, high court or session court's orders. So the issues were decided. While deciding so, the learned court should have done this. The application has been opposed by filing a reply by the appellant defendant, that is the Union of India, and they very clearly says we are trying to finding records by trial courts under issue number 3, filing of cross appeal objections, and yet under the order 41 they moved this kind of an application to assail the findings of the court below time and here. It has been contended that the order to prove the facts that neither the appellant defendant are owners legally of the land below Bungalow number 102 cannot be disputed, nor it was recorded in the records maintained by the appellant that the land below vests in the government. So it is no point of leading additional evidence. This is what the Union of India is countering. It has been contended, pronounced, the judgment. So now the court, after these 2 applications and reply, vets into us Now, what is the Union of India Council arguing in the court? For the appellant defendant that the present appeal has been decided on substantial question of law, as it is a regular second appeal and not on facts. It is further contended that no cross appeal objections were filed by respondent plaintiff before first appellate authority, and rather the appeal and appellant defendant was contested by respondent plaintiff on the grounds of limitation, and that by accepting the plea, the respondent plaintiff's learned first appellate court illegally declined the request of the appellant defendant, that is the Union of India, for condonation. It is further contended that the regular second appeal is lying admitted since 1983, and now when the case was heard after 27 years and the order was reserved on substantial question of law, this application was moved only on the grounds to move additional evidence. Whether it should be allowed at this stage is the matter. Now, this para is very important for all those people whose resumption cases or RSAs are lying pending, from Agra to Fatehgarh to Mau, which all list I have, Allahabad, RSAs are pending in courts and they are sleeping over to their cases. Please, if any finding in lower court and session court is against you, you will get fucked. Nothing will be left with you. So the court, when the arguments were inclined, the best thing what the court interprets is, however, the present second regular appeal is being decided by this court only on substantial question of law. No cross appeals were filed by respondent plaintiff before the learned first appellate court. Rather, the appeal filed by the present appellant was contended by respondent plaintiff on the grounds of limitation alone. The same was dismissed on limitation. He is admitting everything is done. So what do you do? I have latest judgment if a first appeal is dismissed on limitation, and RSA cannot be filed. Latest 2020s. But my honorable judge 2011 was not willing to agree to this. No, it could not be a revision. These are some judicial mistakes which happen because a degree was made in the sessions court. Why was a degree made when it was dismissed on limitation? Because the argument took place on that application. So he is saying because the arguments took place, so we both have been a part into it. So that means he is saying, there is a saying in the courts कि कच्ची में dismiss हो जाए. जैसे ही आप application लगाओ, writ लगाओ और first hearing आए, motion of notice भी ना और कच्ची में dismiss हो जाए on limitation, तब section 100 लगेगा उसमें. Because there is, unfortunately, the Britishers made these laws to keep us gulams, and this is where we are creeping into. So the learned counsel plaintiff at the time of argument has failed to convince this court as to how the said necessary documents would be of benefit to his controversy. Why? Because I had fixed in about 101 to 145 pages, 7 resumption notices, surplus land, resumption policy 73150, how land is being misused, a CAG report that Ambala has surplus of land. So everything was there, but my confidence in my knowledge in 2011 was not there, and it is a very small saying that sometimes the doctor cannot treat himself. So maybe I was a researcher at that time, and then Deepak ji was with me. So we two were influencing into each other too much. Today, after Deepak ji and after parting with Deepak ji also in 2015, when he actually became, he was against the association and my desire of no free lunches and legal charges, I worked hard on the law. I did my law. I understood the laws. Now I know what the pleading should have. Hence, in view of the aforesaid admission, now friends, now admission in my case is the vital doing. That is my salient exhibit D1, which is the best piece of evidence on the point it does not lie in the mouth of the respondent plaintiff now to say that Union of India has got no concern to you. So please, all of you whose sale deeds speak that it is a land under regulations, under cantonment property rules or acts, any kind of such languages, this will kill you. So old grant GJO under section 21 of the Evidence Act, admission is held to be a relevant piece of evidence, and Mr. Das late, even his HOR, his legal heirs were not brought by the defendants. Neither my mother wanted to move because I was the L.R. of my father as per his will. But we could have moved an application like it was moved by the defendants Union of India in the case of Sagar Cantonment. But here they did not want to do it because they found one of the legal heirs. Even in Sagar's case, his wife was the owner. Here also the wife is the owner. The system is vicious. So respondent plaintiffs have stepped into the shoes of the old grant as per the predecessors, and hence the land exhibit D1. And now the court is vetting the judgments which I used. This is very important in his para. This judgment runs into some 62 pages. Divanchand Peshoriya does not rely upon me in the ratio of decidency because in that case there was no PP Act. Here the department has initiated a PP Act either. But have they persuaded it? No, because you went to the court, took a stay against the PP Act under Order 39 Rule 1. So Divanchand doesn't have. Now I talked of Tejinder Mohan Libherhan. This is a vital judgment in Ambala Cantonment, a bungalow leased under perpetuity of 1899. The bungalow till Supreme Court was held that the owners of the bungalow are the owners of the suit property, and it was an excised area property which had gone to the Ambala municipality on resumption. The court says no, it cannot be taken in ratio of decidency. Why? Because in that case there was no admission. Bhai, understand, in a lease you do not need admission. And then the second that property had gone to the civil area, even if there was an admission, I was fighting to the court and saying that in that case, UDC Bantaram had given a statement that Ambala does not fall within the Governor General order or the Bengal Presidency. Court did not want to listen. Redundant. Satish Chandra, I don't know how many judgments I tried to quote. But then I realized there, if the court is not willing and it has already made up its mind, it becomes a waste of energy at some time. So now we were trying to, now I realized, and when ML Gupta ji used to come from Samrala to the High Court Chandigarh, so when we saw the court was actually not willing to counter neither additional evidence, neither these judgments that GJO is not applicable and we are a rent-free grant. So we said, let's switch over. So Shailendra and me, by this time Sanjay Majithia had moved out. So Shailendra and me, we converted the entire argument to compensation. That how will the department compensate us? So now we examine the petitioner contention that before issuing the notice, the compensation should have been afforded an opportunity. Principle of natural justice will always step in where civil rights of a person are involved or where some quasi-judicial functions has to be exercised unless the application of principle is excluded relevant. Now what does the Honorable Court conclude in its para? That's very important in this case. That the resumption of building and the site underneath becomes operative on the date of expiry of 1 month notice. Given the petitioner under Regulation 6 in question as resumption of the building is dependent, it is that the incumbent upon the third part is very important to understand what the Honorable High Court said. That since the petitioner had not been afforded an opportunity of hearing in regard to the quantum of compensation for the resumed billing, we direct the respondents to afford an opportunity of hearing to the petitioner in regard to the assessment of quantum of compensation for the resumed building, thereafter quantifying the compensation of the said building. Now friends, this finding alone gave us a lot of confidence that the Honorable Court has clearly said what 64,000 was calculated was wrong and it needs to be done, and the petitioner, that is my mother, will be a part of that proceedings. So it was decided, since one of my very senior brother-in-law was he was the retired Chief Justice of Punjab and Haryana High Court. So he told Chachi ji, why do you want to go to Supreme Court? You are already 80 plus. What if the Supreme Court overturns this finding of compensation also? And when you already know there are a lot of judgments against. And remember guys, 2011 May when this order came, I was not holding a lot of judgments in my hand. I had not become an advocate by. So there were a lot of apprehensions which advocates. So we approached some advocates in the Supreme Court. Either I prepared the SLP, either grounds of appeal and everything with Mr. Shailendra, advocate of Chandigarh. But we realized when we approached these advocates, nobody was willing to file it because it was running into some 30-40 pages, facts, evidence. So everybody was willing for an amount. I think one Mr. not to be named was the one who actually at that time said, Ronnie ji, I'll charge 2 lakhs. But we thought even paying him 2 lakhs, will it be worth? Because AOR, then filing, typing, I had done every typing myself. So nothing as an AOR, he had to type my lower court judgment or any of my applications or any evidence which had to be filed. Even the resumption policy, whatever. That is why I tell people, please type your judgments, please type your evidence, because this will be required in High Court and Supreme Court. Don't sit over, take a small typist, give him, this is a page, better just type it. Now you can download judgments in PDF and they can be converted into Word with the latest PDFs which are there now, if you have an original software. But if you do the scannings of the old PDFs, the words get distorted. So now coming back, the Honorable Bench was very clear that compensation. Now where did these facts actually drove in from? It drove in from Justice Tekchand's case, that is a Bungalow number 40 in Ambala. As per Regulation 6 of the order, Union of India is having right to resume the site without assigning any reason, and the requirement is to give 1 month notice, which is to be given in the present. So this was against us, but the other part of it was that compensation needs to be decided, and I'll share this Bungalow number 40's judgment and order also in coming video. This bungalow was originally granted in 1959, a 1000 square yard commercial lease plot within its old grant bungalow. The substantial questions which I just said were framed and decided in favor of the appellant defendants and against us. However, it is admitted that no opportunity of hearing was given to the respondent plaintiff before determining the question. Hence, they have a right and construction should be given. Now, this para is very important, which the Honorable Court, hence the impugned notice, to the extent it conveys the compensation payable regarding acquisition of building as only 64,126, can be said to be bad in law. So it is incumbent. So 64,000 was said as bad in law. So the final observations came that the resumption of the building stands from that same period of 30 days, and since PP Act had been initiated under Regulation 6, it goes. Respondents need to be given their compensation and due hearing. Why I picked up this case, why I am so clear and honest with all my fellow bungalow owners. Guys, I have been strangulated because the department knew if I get the case remand back, I'll not let this bungalow go. I know today say that even today the bungalow is not being put to use by the army, and I'll not let it do it till they don't compensate me. 90 hours of arguments in the court. But then Sanjay Majithia was stuck into it, which I realized more than 140 judgments we quoted. I have all records. I don't know how many cantonment judgments I dug into. I remember those days those softwares were not available and we only had a software from some bungalow owner in Lucknow, I remember. And he was selling it for 70,000 rupees. No grade he tried to give it to me since being a researcher. He was doing business with me, I remember. Everybody in this world is doing business, yaar. So, this case, so many discrepancies from either sides, from applications to pleadings to evidence. We were unable to get the right issues made. We could have used that surplus land. We could have used that similarly situated 7 bungalows have been left. Why not me now? We could have used Manalal Agarwal's case, that the case was remanded back in 2011, but the judgment was not with us at that time. We could have used Sagar cantonment case, P.T. Anklesha or Purushottam Das Tandon, these were all with us, but they became of no use because admission was becoming conclusive because my father did not plead and his senior most counsel, Mr. Libherhan, did not plead during that period. So everything, condonation was not fought well, limitation was not taken seriously. We didn't know how to do it. And I'm sorry, but sometimes the legal people sitting up there also don't do it. Reasons better known to them. Guys, I'm a victim. Try and understand. Even after 2011, I assailed my case. I went into court. My mother went into court. She volunteered that she will hand over the possession of the bungalow. You decide my compensation as per the High Court's order. I'll leave the bungalow. Give me a lease period, license period of 2 years plus, and I'll leave it. Give my plot. The whole Ministry of Defense, the whole team of IDS officers then. I remember there was an officer, I refused to hesitate in naming him Ajay Chaudhary. Advocate Prem Sagar, advocate in the High Court, what was her name? I'm forgetting. Ranjana Shahi. They were fighting against this case as if it was a personal fight for them. And I was trying to, fight the system, the government of India. I tried. But nobody was at support. I remember Deepak also, in the later parts of the days of arguments, he used to go for the earlier parts because I travelled with him for all his court cases till Supreme Court. But then he started giving up because arguments used to happen either in the morning or later part of after the lunch. The Honorable Court used to call us, let's do it after lunch. And so we used to be busy till 4, 3. So these applications, section 100, cross appeals, objections, so many technical issues, and I have so many judgments which speak of it. So guys, if I lost, and I know where I lost on, I know where I lost my battle. And that's the warrior which is said. When he knows his weaknesses and he admits to those weaknesses, and the reasoning of losing is his weaknesses. Those weaknesses were not due to me or not due to the circumstances. They were there because I was not educated. So my humble request, don't sleep over to these RSAs and SLPs. Work hard. You are going to fight these men in uniform, the corrupt system in the IDS officing, and the legal officers who come up, shout on top of their voice, national security. They don't plead national security. So it's a very different story. My case, I know. So I would request if everybody would just wake up, understand this case of mine, and then move forward. Thank you. Good day.